Good afternoon, everyone.
Good afternoon.
I am your chairperson for the session on research as a component of judicial training. This is one of the 4 concurrent sessions for this afternoon under the theme Training Methods and Goals. We have 3 speakers for this session. This session aims to provide a comparative analysis of how research is used as a component of judicial training. We will now proceed to the session proper, but first some house rules. For the security reasons, we enjoin everyone to wear your IDs throughout the duration of this conference. We request everyone to please switch off your mobile phones or devices or keep them in silent mode. So that we can adhere to our program schedule, we will do away with the introduction of our lecturers. Profiles of the lecturers are already included in your respective kits. To adhere to our program schedule, our speakers are requested to strictly observe their time allotment. For this session, the speakers are given 1 hour for their presentations. To help you keep with the time limit, please dispense with salutations and acknowledgements. When 5 minutes remain, we will flash a cue card signaling that you have 5 minutes to wind up your presentation. Another cue card will be flashed signaling the end of the time allotted for your presentation. Should time permit, we will have an open forum before the end of the session. Should you prefer to write down your questions, question slips are available in your conference kit. We can also use our respective microphones later. Members of the Secretariat are on hand to receive your written questions. May I now call on our very own PhilJAS head of the research publications and linkages and the Dean of the Ateneo Law School. Please welcome Dean Sedfrey and Candelaria to deliver research and judicial education.
Thank you very much, Attorney Elmer. Good afternoon, ladies and gentlemen. I'd rather walk around. It's an unholy hour. This is really perhaps the most challenging time of the day. Filipinos usually on a summer would take siesta. That's the Spanish tradition. But here we don't have the luxury of siesta, so hopefully we'll wake you up a bit for the rest of the afternoon. I'd go on for probably half an hour at the most, 40 minutes, but feel free, I think, whenever you have some burning questions to raise it, no? Since we have enough time for our afternoon session. The task given me is really to look at research as a component of judicial training and education in a larger sense. And I'd like to share, moving on the presentations, looking at how we have at the Judicial Academy identified some research issues that somehow inform training programs. Sometimes research can also be triggered by some concerns arising out of the workplace of judges, and that could also be an important trigger point for us in trying to design a program for judges. So from time to time, I would refer to at least 3 major items in every frame. One is what was the research goal or issue that we wanted to inquire into, and then how did this translate into training and eventually publication. These are normally the components of what we have done for the last so many years at the Academy. And it may not be the most perfect approach. You might have your own experiences that you can inform us as we move on. So please free to inform us on how you may have done it comparatively within your jurisdictions. Okay? So I also do a thematic approach. I will select some of the key programs that we have identified. I cannot go through everything, but I'd go, for example, through some themes like child sexual abuse, environmental issues, extrajudicial killings, for example, law and economic development. And these are some of the themes that I will somehow present and hopefully could contribute to our discussion for the afternoon. Okay? So this is really my objective for the afternoon, to demonstrate how research could be used as a tool for curricular development in judicial education, and sometimes it may lead to policy changes In fact, in some of the programs that we have undertaken, we have to recommend to the highest court of the land the development of some direct changes on the rules whenever the rules may no longer be relevant or practicable for use by the courts today. Okay? So I would also try to link this, of course, to the experience of the IOJT in terms of the core principles. No? And two core principles I would refer to would be independence. No? How do judicial training institutes maintain independence in the design, let's say, of their programs whenever there is a lot of offer or linkage happening? You will see in some of the frames that we will identify some of the development partners that have taken real interest in the programs. And you know this by experience, I think, in many of the jurisdictions, international development partners, no, or non-government partners could also present some of their agenda. And sometimes it could be a very sensitive matter for the court, since we want to maintain independence in the delivery of judicial education and training. The other one has been the more innovative changes, I think, in terms of approaches to judicial education and training, and that is the multidisciplinary character now of the delivery of training with the judges, the justices, and other court personnel. And you will see a mix of science, a mix of psychology with law, and this seems to be the trend now with much of the training that we have undertaken. And it has helped a lot our judges in trying to appreciate the application of other disciplines in the context of, let's say, court cases today. So having said that, let me begin with some of the, I think, the most important developments that we have undertaken in the Philippine Judicial Academy in relation to the courts. For example, I'd focus this time on legal protection of children. Okay? The Philippine government was privy to the Convention on the Rights of the Child sometime in 1990. And there was a massive effort on the part of the executive branch and the legislative branch of our government to implement the Convention on the Rights of the Child. So one of the most important changes undertaken in the 1990s was the adoption of anti-child abuse laws. And if you look at the decisions of our Supreme Court, it is very telling on how society perhaps may have treated children. You just open one volume of our Supreme Court decisions for the month, and you can almost readily see rape cases, acts of lasciviousness, sexually related offenses. That occupies a bit of our Supreme Court's decision making. Sometimes it tells you, how is this happening? What are the remedies that have been introduced in order to address this level? The anti-child abuse law, that is Republic Act 7610, was one of the most, I think, pioneering efforts to introduce certain concepts of child abuse. No? And to a certain extent, it was a challenge for the court, because now you have certain respondents. You have also complainants. No? On one hand, you have complainants who are children, and there was a need to undertake perhaps a very creative way of presenting them before the court. The rules were lagging a bit at the time from the legislation. When there was an effort on the part of some non-government groups to approach the judiciary for multidisciplinary training on child protection, Save the Children came forward. Save the Children, as you know, is an international development partner. There was a local group from a university, that's the Ateneo Human Rights Center, that partnered with the Judicial Academy. And one of the goals of this training was really to approach it from a multidisciplinary components. So what did they do? They looked into the presence of various stakeholders. Aside from the judges, you would have the prosecutors together. You have the public defenders. We call them the public attorneys here. And then we also had psychologists. We had psychiatrists. We have social workers on the ground. And they all came together in a training program. A curriculum was designed to address the very interesting mix of various stakeholders. And this somehow was passed on to other training activities in the long run. So it started with the pilot program. And then eventually it got into a institutionalized programming within the academy. One of the attempts here was to identify a tool called video. They call it video conferencing of children. Okay? At the time, they were trying to grapple with the issue of how do you present a minor, a child, let's say 5 years old, 7 years old. That was very challenging for the judges at the time. We had the family court system way back during the period of martial law, during the time of President Marcos. That's Presidential Decree 603, the Child and Youth Welfare Code. But since we adopted the Convention on the Rights of the Child, we were challenged to adopt new rules that would address the concerns of children. And so one technology that was introduced was, they call it video conferencing system. And eventually we will show you how judges also were to be trained on the use of such a technology where the child would not be present face-to-face with the accused, but would be inside a chamber. But you have a gadget where the judge sits inside the courtroom, but is able to communicate with the child in her chamber. But the child is prevented from seeing the accused face-to-face, because that can really be intimidating. And the child will not even talk the moment he or she sees the accused. So that's one of the offshoots of this training, where they had to identify a method. Okay. So here is an attempt to try to inject some changes in the rules. For you to be able to introduce this, then you have to look at the rules of court. How do you now use a gadget of this nature to creatively present, let's say, minors, in court? So at first it was very crude, but UNICEF had decided to take interest here. They tried to look at some more advanced technology to be able to equip some family courts at that time. When Republic Act 8369, that's the creation of the family courts in the country, was adopted in the middle of the 1990s, again, one of the more creative changes in our laws and eventually in our rules, because of the Convention on the Rights of the Child. They pilot tested this in some family courts around the country. And again, one of the ways to do training after that was to be able to make the judges acquainted with such gadget. How will they now operate it? Some could not even handle it in the very beginning. So it will entail training for the judges, where the child will be there, and what kind of questions will now be allowed in the course of the, let's say, oral examination. Okay? So this had to inform our judiciary on the kind of new rules that will be adopted. And as a result of this, they had to consult the judges, the stakeholders, on how do you now recraft a set of rules. Those rules will now become the rule on examination of a child witness. And the Supreme Court took the lead this time to carry it out within the court system. And in the rule on examination of a child witness, aside from the use of this gadget, there might be ways by which you will have to assist a child. And some of the persons who may be allowed to assist the child are support persons. Someone who might be close to the child to be present in the proceeding. It may be a social worker, okay? And you have facilitators also. You have interpreters now that will allow the child to be able to convey what he or she has in mind. And so we now had to bring in psychologists in our training program. And this is where interdisciplinarity became very important in the realm of child protection. Okay. For purposes of institutionalizing this, we had to work with some agencies of government. And this is where linkages now would come in. My office is research, publications, and linkage. We tried to put together this function in one office to be able to have a natural link between the design of the curriculum and then make sure that this is institutionalized through certain changes in the rules and eventually let it flow into a training program for our justices, judges, and other court personnel. And this is how we have proceeded. But with great help, of course, from certain offices like UNICEF, the Commission on Human Rights, Child Rights Center. You have a technology office, no, that has volunteered to help in the video conferencing system. And of course, you have the local channels, no, who had lent their capacity to be able to develop some tools for purposes of video conferencing. Okay. Yes, sir, please.
May I need some clarification?
Yes.
Perhaps you started this research in the year 1998.
In the 90s, yes. The middle of 90s, yes.
May I know whether it was quantitative research or qualitative research, and before conducting your research, what were your hypotheses and what sort of tool were used to conduct that, to carry out that research?
Okay.
And once certain, whether the hypothesis proved affirmatively, and if so, so how much time was required you consumed to implement that study?
Yeah. What we have done initially was to do a survey of the situation of children in the country, and this has helped the UNICEF, for example, the Department of Social Welfare and Development, no? That's the official government agency.
Survey was based on interviews or the questionnaires?
It was both focus group discussion. When you say focus group discussion, you identify a group of stakeholders, small, but on a larger plane, of course, you can rely on statistics, figures that have been there for a while, and UNICEF, together with some of the non-government organizations that we have worked with, including the Department of Social Welfare and Development, have ready figures for us to identify. But those did not necessarily focus on, let's say, the justice system. And this is where we had to bring in the court perspective, the court situation. And for us, the initial indicator was, what are the types of cases that clog our courts, for example? And we started with baseline information. What is the magnitude? When I mentioned to you the kind of cases that go up to the Supreme Court, it is very telling. You would see the number of cases that have gone up there. There was inquiry into the process. How long did the process take place for a child to go through a criminal procedure, let's say on child abuse cases? These are the information that were made available from both within the court and outside the court system. And from there, we decided to put together an inquiry on how best to address, let's say, the rules right now. Are the rules sufficient on the basis of the information that we have gathered? And to a certain extent, the court had been convinced that perhaps it's high time that we may have to review part of our rules on criminal procedure that is generally applied to adults and children. But Here is an attempt to focus just on children. That's why the rule on examination of a child witness was a special set of rules that made even exceptions to the general rule on criminal procedure. For example, the rule on hearsay, as you know, that ordinarily would not have stood the test in court. But for children, you can make narrations. Somebody who is examining a child can allow the child to just continue to narrate stories. Because the usual way of applying rules on criminal procedure will not be productive for a child. You allow the defense lawyer to start objecting and objecting to questions, you will never be able to get a straightforward and clear testimony from the child. Besides, the child can be intimidated. And so this has helped us calibrate the kind of rules that perhaps would, at least to a certain extent, address also the constitutional right of an accused. One of the concerns we had at that time was, will this be unconstitutional? Where you place a child inside a chamber and the judge sitting here and the accused present in front of the judge. We have a constitutional provision that says the accused has the right to meet the witnesses face to face. Will face to face actually cover a situation where the child is outside the courtroom but in a chamber, but using a gadget where the judge communicates to the child and to the accused in a different manner? Well, fortunately, it has never gone up to the Supreme Court, which means it would be the court itself reviewing its own rules. And that would have been difficult for someone pleading before the court to say, your rules are unconstitutional. That has been done before, but we thought that this was a constitutionally well thought out rule that would have made an exception for children. So that's the first storyline, and it went through a number of years for us to be able to adopt the set of rules, but with very deliberate effort on the part of the academy. Thank you. I hope I addressed some of your concerns, sir. Thank you. Another one that was also quite interesting, aside from child abuse, we had embarked on a new set of rules that address what traditionally would have been called juvenile delinquents. Of course, that's not politically correct now. The internationally allowed term, or at least adopted term, is children in conflict with the law. And the Philippine practice for a long time has been even to put children to detention areas. The Convention on the Rights of the Child and the Beijing rules, the real guidelines would have said detention is a last resort. We have seen some models, European model, North American model, where a child below 18 does not even go to court, does not even go to detention, because the method of dealing with children in conflict with the law was varied. And it would graduate them into a worse, perhaps, offender the moment they spend time with adult detention or detainees in our country. The challenge for the government was, do you have enough facilities in a country that is developing? We don't even have enough for our regular detainees. What more for children? While the law mandates every local government to actually set up specific detention areas for children, that has not happened for a long time. In fact, children spend time with adult detainees. And as we said, they graduate into higher forms of reoffending in this country. But the legislature passed the Juvenile Justice Welfare Act. This is one of the other sets of laws after the Convention on the Rights of the Child. And here, they adopted the norms in the Beijing rules, the Riyadh guidelines, where diversion was a method to put children outside the so-called formal justice system, and to deal with them in a manner that will address their psychosocial perhaps incapacity at that time, at that point. So if you look at these components of the research, we had to look at the different pillars of the justice system. In the normal structure of our justice system, we have the prosecutors, we have the defenders, we have the judge, you have the social work office, no? And you have the community. That's the so-called pillars of the justice system in a very traditional way for us, no? And so our attempt was to put them together in a training program to address, with the new law, how will you deal with this? Diversion is a very new concept at that time, where the court, through the clerk of court, would be convening a committee called the diversion committee. And that will involve community, that will involve the court, that will involve also the prosecutor, no? And the defense lawyer, to design a process where you would divert the child. That was an attempt to move them out. Of course, there are offenses that definitely may not be susceptible of diversion. The other innovation here in the new law was, in fact, the responsibility of parents. No? How much more could you make parents engage and responsible in this regard? The situation of many of the children who go into conflict with the law are those in the fringes of society, the low income level. And the poverty situation in various communities somehow had affected the manner by which parents have been able to deal with the children. And this was a big challenge, in fact, for us to see, while the laws, the rules can be set, the socio-economic component is a big challenge for us. You bring back the child to the home, and there is nothing to go back to in terms of constructive, let's say, employment for the parents or even the child. Then, child ends up in terms of reoffending. Now, non-government organizations became very handy here, because the non-government organizations were able to put, at first, what we call halfway houses, where they prepare children to be reintegrated into the family setting. But that is not widespread. That's the problem here. That's not widespread. There might be well-funded non-government organizations, no, that can do it, but only for a fraction of the population. But the model is there. The model is there. So when we had to do this judicial training for the judges, no, the judges had to grapple with a new concept called diversion, the so-called juvenile justice. What is juvenile justice? No? And our appreciation of juvenile justice for a long time was very much the classic revised penal code provision, punitive in character rather than restorative or rehabilitative. Yes, sir.
Do you have exclusive courts for juvenile?
Yes, they call it the family court system. Today, there are designated family courts, but Judge, correct me if I'm wrong, that there was already an attempt to place permanent courts as family courts, no? Because for a long time, when the law was passed, it was merely designated. And it was a very ideal court, no? It was an attempt, in fact, to go back to the old system where you have a one-stop shop. You have a social services counseling division right in the court, no? So that would have been a one-stop shop attempt. For some time, we lost that system. Now we are reverting back in hopefully a more enhanced manner. But the challenge now is, who would want to sit in that court? Because the kind of cases that you will end up with, like Judge is smiling here, if you're a family court here in the Philippines, you bring back all the pains of the day. You're not just with children, but you're with the family issues. No? It's very exclusive. And in fact, in some courts, the law was crafted in a way that if there is a criminal case and a child is involved and the rest are adults, the case goes to the family court. So we have one experience of a judge. She was narrating her experience in a terrorist situation down south. There was a child involved, but the rest were adult terrorists. The case ended up in a family court. And it was very, very challenging for the judge. You have about 20, 25 alleged terrorists with a child involved there. It ends up in our court. That was really scary for the judge. For some reason, she decided I'd go to the Court of Tax Appeals. She ended up with the Court of Tax Appeals where she had better peace, no? But of course, you're saying that's a cop out, no? But it's realistically, I think, understandable. Yes, sir.
In our jurisdiction,
Yeah.
this situation is arising, then cases are trial is initiated and is divided, and the adult is kept
Separated.
and the child is child's trial is initiated before the juvenile.
Yeah. No, I agree with you. That would be the ideal. Unfortunately, the law was crafted in such a way that for as long as a child accused is involved, it ends up with the family court here. We might learn from the experience of how to craft a rule that will segregate, no? Because the evidence for the child is the evidence for the rest of the terrorists, for example. Yes, sir. Ma'am, sorry.
So in my decision, what they would do, you have the trial of the child in the adult court, but when it comes on for sentencing,
Then you do
send to the juvenile court.
the juvenile court.
So the
That's
judge-
interesting.
Juvenile court sentence the child, but the judge in the adult court sentence them. So the one evidence will go whatever one.
Okay. That's interesting.
And it makes,
Yeah, that makes better sense, I would think. Yeah.
The trial is joint
yes, it's the same evidence.
with the adult court.
Yes.
Mm.
And then with the sentence, you commit the sentence, transfer it for sentence.
Well, we have yet to address that because we don't want to lose some very committed judges, no? Who would really be child sensitive, no? And only to end up with Court of Tax Appeals. Not that I'm saying the work is less important, no? But you know, it drives away because of certain challenges, no? The family court judges are perhaps one of the better trained judges. When I say better trained judges, in a multidisciplinary setting, because they are more exposed to child sensitivity, gender sensitivity, which of course my colleagues will tackle in the other half of our session, no? And they have really benefited from this. Judge, you were going to contribute anything on your experience?
I'm a drugs court.
You're a drugs court. That's
So
worse.
if there's a minor charge, it also goes to the family.
Family court, yes. That one is also telling in our country now, where there's an anti-drug war campaign of government, no? And many are really couriers in the long run. They end up as couriers, no? If only to avoid. The other challenging part of the law and the rule, let me just finish the sentence, is that whenever a child would be accused here, there is the benefit of, as we said, diversion, and the adults, the adult offenders, use this as an opportunity to evade responsibility because the child they know will not end up in detention. So they will use the child as the courier. And that's why many children are ending up, you know, also in the drug problem. Yes, sir, please. Yes, please.
My name is Shahzab Saeed from Punjab, Pakistan. I'm made a trial judge.
Yes.
In our jurisdiction, when there is a child offender, along with other adult accused, the same court will try the case. Their cases will be separated, but the proceeding will be commenced separately. In evidence will be recorded both the cases simultaneously.
Similar to what you were saying. Yeah, very similar.
But the difference is that the child cannot be sentenced to death if he is found involved in the case. The punishment can be awarded as life imprisonment.
Yeah. Yeah, because the by tradition and by application, it's a lower penalty because of minority. Yes, that's it.
The USA is not signatory of CRC, and in 1990 they awarded capital punishment to a
Yes,
so
you cannot impose. Yes.
they awarded capital punishment
Mhm.
to a child who was 17 years
Really?
old in USA. And there are numerous examples. They said because they maintain record of their criminal activities, and according I studied that case, and according to them, the child committed 3 times rapes and equalities and like that.
Yeah.
And ultimately, she murdered a woman, and that is why
They impose.
he was awarded capital punishment.
Yeah, because the CRC would have not allowed that under the situation. But the US, I know, has not been predisposed to going into human rights standards in many cases.
They are not signatory of CRC.
Yeah.
There's the
Yeah.
perhaps this is the in few countries did not sign.
Yes.
But USA is one of them,
Yeah.
and that is why they are awarding capital punishment to the children.
Yeah. But we have a joke there. What are the 2 countries that did not sign the CRC? One has the most established system of government, the United States. The other one is without government. You guess what country? Yes, sir. Somalia, you're right. 2 countries. Very interesting. Okay, let me move on. So, what did we do by way of publication here? So, we did research, we did training, the rules have to be implemented. We did the Juvenile Justice Training Manual. So, this is for different stakeholders. You have for prosecutors, you have for judges, you have for public defenders, you have for social workers, and you also have for non-government organization. So it was going to address them on at what point, let's say, will you be able to apply the rules if you're a social worker, if you're a defender. So that was the manner by which the manuals were created.
Is it available on your website?
Yes, of course. You have here my colleague who's very much in charge of this. No, but we have the soft copy.
Okay.
It can be given.
Thank you.
Anything you would need here, please let us know, because we can share this soft copy. We've run out of the hard copies in most of this, but soft copies would be better. Thank you. Okay. Now, again, you might take interest in the linkages, no? Because some development partners have their own niche. They would really approach you. Attractive, yes, but where are they coming from? Of course, no? We always inquire into that. So you would notice here, we have now USAID. You have Royal Netherlands Embassy. The Dutch had a very interesting way of dealing with children, no? Very advanced, you know, I think, and very liberal in the manner that they have dealt with juvenile justice issues and even anti-child abuse cases. So they were privy to some of the design of our training program where the technology was not available yet for us, and they shared that. You know, the anatomically correct dolls for a long time that was used, but of course I think they are re-examining the use of anatomically correct dolls in trying to ask children to prove how were you actually abused, no? And they would present these anatomically correct dolls, no? For a time it was being used, but I think the literature is saying perhaps we may have to re-examine the use of anatomically correct dolls for children right now. But for a time that was the Dutch project that we have for a while. Okay. Let me move on. Okay. Kasagal. One of the things we identified as problematic in the implementation of the rule on examination of a child witness and even the Juvenile Justice Welfare Act was the dearth of people who are really interested in following through the procedural process in court. When I told you that one of the problems was that many children come from marginal families, economically deprived families, they don't have the time to inquire with the court. What is happening to my case? No, they don't have the time to visit. They're busy trying to fend for themselves, look for the next meal for the family. In a family of 4 or 5 and one is detained, one is abused, how would you be able to do this? The court-appointed special advocate, guardian ad litem, was a way by which we can identify some responsible citizens. Volunteer, no? So you embark on volunteerism of people who might want to offer their services. These are professionals. They might be teachers, they might be other practitioners in the field, but they offer their services to somehow help in trying to reach out to these children. So this was a training that we did and developed a module on how to become a court-appointed special advocate. To be able to do this, we had to approach the judiciary and tell them, here is an organization of volunteers who would want to help children in the family courts who might need assistance, no? Either by just following up on the cases, looking into the family, and trying to link the child with the family. That is the court-appointed special advocate. And there was an organization that was put up nationally to address this, to fill in the void. The branch clerks will just issue the orders, no, to appear, but who would follow up on that? They're supposed to be sheriffs, but sheriffs may not have all the time because they are issuing so many orders in different parts of the country. So volunteer groups like this, authorized by the Supreme Court and through the judges, are able to reach out to some of the children. There were very successful projects implemented, but again, this will require a really committed group of people to be able to attend to children's issues. Now, I'm done with children. I shift to another theme, if I may. Environmental justice was a new thing. When climate change came, when La Nina, El Nino came, we were affected. As you know, the country is visited by how many, what's the record for typhoons every rainy season here? 40? 30, 40? We're still at the tail end. Yolanda, the Haiyan, the worst that we have experienced happened in November. We just celebrated the anniversary this week. And environmental damage is not just natural, but man-made. And one of the challenges now is investment, mining concessions, natural resource development. In a country that wants to develop, use the rich natural resources, we are confronted with a dilemma. It also affects rights of communities, like indigenous peoples, who actually inhabit areas where mining concessions are granted by government. You have a department called the Department of Environment and Natural Resources. Traditionally, it was really made to issue permits to partner organizations, partner institutions, foreign investors, 100% foreign-owned, come into the country and develop the natural resources. But the residual problem is the damage caused to the community. So we've had terrible disasters here, affected by mining and some other irresponsible use of, let's say, resources. No? Pollution is prevalent. No? You will see the country, you've seen the jeepneys. One day you should ride the jeepney. Probably we should do a tour for you. The jeepneys are a post-American World War II model jeep. And you can have 10 to 20 in one jeep. No? But it is causing a lot of pollution. They will not turn to unleaded gasoline. They use diesel. No? And now they have a big challenge here. The Department of Transportation and Department of Transportation is introducing an e-jeep. They call it e-jeep, electronically powered jeep, no? Which will not require diesel, gasoline. No? So we have these challenges in the country, and one of the issues raised before the court was, are the courts prepared to handle environmental damage issues? There was one case that was adopted by the Supreme Court. It was a test case. It was meant to put at the highest level of our court system the concept of intergenerational responsibility and also the precautionary principle. The right to a balanced and healthful ecology is enshrined in our Constitution. Now, we've learned a lot from the South Asian experience, no? Where you use the right to life. Let's say the Indian Constitution has used it to actually promote environmental protection. In the country here, we have a right to a balanced and healthful ecology. That was decided by the Supreme Court. But we did not have the rules at the time. How do you implement legislation that will protect the environment? And this was championed by no less than the Chief Justice of the Supreme Court. At that time, it was Chief Justice Renato Puno. You know, in the country, the word Puno, that's the family name, is translated to a tree. Puno is a tree in English, no? And when they were trying to craft a set of rules that will protect the environment, there was the suggestion that we adopt a wreath, that's a wreath, and they would call it the wreath of a tree. And it would have been wreath of Puno. So the Chief Justice said, I don't think I want my name immortalized, no, in a wreath. Besides, we call it delicadeza here. I must refrain from doing that. No? But we adopted here a set of rules that would allow immediate remedy now before the court to seek a remedy to stop a particular potential damage being caused, let's say, by an activity. No? And as I said, some of the most telling issues would be mining. Now it has gone into other aspects of human activities, no, to stop the damage to the environment. So a new set of rules was developed here. And that was translated into a training program where some 100 environmental courts, if we had family courts, we had environmental courts this time. But you know the challenge for envi courts? Science. How will a judge now appreciate all the issues of climate change, biodiversity? How will the judge appreciate that? It took non-lawyers, of course, in our training to explain the concept of biodiversity, life sciences. No? This was the next creative attempt of the Supreme Court to inform our judges. No? And they will have to work with scientists here. How do you evaluate damage on the ground? That again would be challenging. We've not even talked about official government policy on mining, because that is an executive branch matter altogether. But when these things are done by the executive branch, it ends up with the court. And so, as a result of this, we had to develop training manuals, we had to designate courts, and eventually even introduce interactive ways of understanding the environment. So now, you can talk to some of the environmental court judges, some of them are here, in fact, in the conference, and you can ask them how challenging it is now to apply science in the context of protecting the environment in the courts. Okay, so I'll just go through some of these publications, and these are really also distributed to the judges and other stakeholders. Yes, sir.
In our jurisdiction, the environmental issues by a tribunal, and the tribunal consists of two persons. One is on judicial side, other is on technical side.
Okay.
Scientists. They both hear the
Is
case,
it?
and the technical man assists to the judicial side officer, and they both will decide the cases.
That's interesting. Are they like a commission of sort? So because sometimes you can designate somebody like an expert resource person to inform the court of this the issue. That's a good practice, I think. Yeah. Here they would rely more also on non-lawyers sometimes, but we have been able to generate a group of lawyers who are going into environmental law. So the law schools now have, in fact, become more advanced in developing a curriculum for lawyers, no? To be trained in environmental. It's one of the more popular courses now in the country. In fact, it's a mandatory course right now for law schools here to understand the environment. No? So it has changed the landscape of legal practice also. And they are either on the affected communities, or they might be in the corporation sometimes. But it's good for them to be in the corporations also, to inform the corporations on the parameters by which they can perhaps alleviate or prevent any environmental damage in the course of operations of corporations. So this one is interesting. I just want to point this out. We developed a citizen's handbook because in environmental law now, the Supreme Court, through the rules, had relaxed the issue of standing. You know, the strict rule of who can challenge an act or an activity, that has been relaxed. They call it a citizen suit. And in environmental cases, that is a very good way to challenge. No? Before, you would be rejected because you do not have the standing. Are you damaged by that? Today, it has opened the door for a citizen suit in environmental law. We developed one for Muslim Mindanao. We have in the southern Philippines, no, quite a predominant community of Muslims, and we also did one for the autonomous region for Muslim Mindanao, just to make it conform also to the sensitivities of Islamic tradition, because we found out they are very environmentally inclined, no? They are protective of the environment, and we also did a module and a training for that in that part of the country. So we had so many trainings now. We do this, it's one of the favorites of trainings right now, and again, it is multisectoral. We involve the Department of Environment and Natural Resources, the officers who issue the permits, at the same time who also have the authority to withdraw some of the permits given to mining concession companies. Okay. Another thematic, this is probably the second to the last issue. We have introduced issues on law and economic development, simply because of changing landscape of business, no, and commerce. And the courts have now been challenged by new concepts in law and economic development. Trade, for example, while it may not be the daily grind of courts, but there are some key issues on trade, but there are also key issues on business. And today, because of the competition law, we have adopted a competition law. Judges now will have to be trained in understanding the whole concept of competition in a business environment. So we are going to go into a massive set of trainings now on competition because we foresee some of this to go before the regular courts. But the problem is the concept. Economic analysis, no? That's not, again, the grain for most judges. Yes, sir. Yes, what we do is try to come up with our journal, that's the PhilJet journal, where we put together what has been delivered. No? It's really more of a collection of what has been delivered in the trainings. No? Yes, we have soft copies, ma'am. We can probably share that with you. Okay. Again, we will do that for you. We have the soft copies of this. Okay. So this one is translated into manuals, no? And we've done roundtable discussions. One of the forthcoming activities we have is to bring in a couple of UK professors who are into competition law, because competition law is very new to us. We would like to see the experience of Europe, perhaps in Africa. Sir, in Africa, is competition law something that's not much at this point, no? Nothing. North America, yeah, but we are drawing much from the European concept. So we are bringing in a couple of professors through the UK embassy here in Manila to dialogue, mind you, with the justices of the Supreme Court. We have a champion inside the Supreme Court now, one of the younger justices who had done law and economics, no? In graduate studies, and now he's sitting in the highest court. And he says, I have a group of 4 or 5 people in the Supreme Court who are really very much interested into this. So we will begin with that. You have to have champions of this because the concept is very new. And when a case goes up to the Supreme Court challenging competition law, you will have to have an informed set of justices there. What more with the trial court judges? And so that's the next level of training we will have on law and economic development issues. Okay? International law also has become quite important. People think international law is marginal in terms of local, but yet today, I always say, I teach public international law in law school, and I said, please don't marginalize international law, because anything now happening in a domestic setting is almost affected by an international legal instrument. And that's what we have to tell judges right now. We have to be aware of what's happening there, because there are so many issues that can dovetail into even local litigation today. So we developed manuals here also, and I think this one just goes back to the materials that we have online, no? It's handling of child abuse cases, no? I think there will be some inputs with my colleague. Are you going to do a little on the capacity enhancement training? Will that be part of? No. But we have done a series of capacity enhancement training for certain judges, certain prosecutors. This one is designed in an interactive way, no? It is not lecture time. It's the judge, the prosecutor, the defender there, the social worker, and they have role-playing exercises. That has become very popular in an enhanced capacity training module. Okay? And we look into this by having a module on the handling of child abuse cases. Okay. That's the CET, the Competency Enhancement Training for Judges and Personnel in the handling of child abuse cases. I think this is the last major point, very sensitive today and for some time. This is a national security issue. You're familiar with what has happened for some time here, the extrajudicial killings and forced disappearances. That's a function of ongoing armed conflicts in the country, where certain groups of people sympathetic, for example, to the left movement, have been identified by military sector as in need of suppression. No? For the time, during the past administration that was under President Gloria Macapagal Arroyo, where there was a real attempt trying to address the armed conflict situation, particularly with the left. And it was that period from about 2000 to 2007 when no less than Philip Alston is an international legal scholar, asked to come over to the Philippines to inquire into the series of extrajudicial killings happening. And the court was better minded to inquire what is lacking in our rules to address the extra-legal killings or extrajudicial killings. And they revisited the rules because the manner by which extralegal killings were happening was very difficult to fit into the rules at the moment. For example, you have somebody who is identified with the underground movement, is taken by military into custody without any information to the family or loved ones. How will you go and look for that person? Well, of course, our remedy now, at the time was, of course, the privilege of the writ of habeas corpus. Habeas corpus was available, but it stops at asking the respondent, who is an official of government, a military personnel, or a police, to just say, sorry, the body is not with me. The person is not with me. That's all that habeas corpus would have afforded, right, Judge? So what did the Supreme Court do at that time? Again, in a very creative way, a summit was called. An extrajudicial killing summit among the three branches of government. It was a creative way of engaging the other branches of government, particularly the executive, which runs the military and the police. They went into a very big forum, a no-holds-barred type of activity. They identified the problem, and in a very constructive way, the court offered what rules would be necessary to address this. And what was adopted was not of original vintage, but drawn from South America justice. The writ of amparo and habeas data. What did the writ of amparo provide? If there is a violation of the right to liberty, security of a person, life, liberty, security, you ask the law enforcement officer or the military sector to produce the body. If he or she cannot produce the body, then the writ of amparo will allow the government, let's say investigating bodies, to go into the camps, to look for them, to produce certain documents whenever necessary. So there was an added remedy, and the amparo has now become an important remedy for those aggrieved as a result of extrajudicial killings and enforced disappearance. The issue has resurrected today in light of the anti-drug war campaign of government. You are probably hearing about this anti-drug war campaign and the series of killings that allegedly occurred in the course of the anti-drug war campaign. It's a very controversial issue in the country. But today, the court also was better minded to review. How best could we review the writ of amparo and habeas data to fit it into the context of the new challenges like anti-drug? No? So when you try to look at these cases, they are context cases. So I was listening to the discussions on social context. That is very much alive in what the court has done through the years, through research, through training, and publication. Because we believe that court rules, court policies must now adapt to changing circumstances of parties. And that is how we have developed the thematic issues in the country. So we did trainings on this, and we also had support from other donor groups. Okay? The trial, the bench book for Philippine trial court judges is a regular activity of the court to update, the bench books. No? I think this is fairly common with many jurisdictions. This is done with consultation and led, of course, by a Supreme Court committee. Okay? This one is done from time to time to update our judges. Okay? Access to justice by the poor, again, one of the context issues. We have developed training programs to sensitize judges, to make them more appreciative of the background of people who come before the court, and make sure that the court is brought much closer to the concerns of communities. Indigenous peoples. In the country, there's about 10 to 15%, including Southern Philippines, Islamic communities, who are indigenous in character. Okay? And indigenous peoples are also a major concern for us in the court processes. No? But there is a law that governs indigenous peoples in this country that recognizes their ancestral domain rights. No? But the problem with that is the mining concessions are found right in the domain of indigenous peoples. Okay? We have regular publications. We have a bulletin that informs the public and also our court personnel on what is happening in terms of training. This activity will definitely be an exclusive issue of the bulletin. No? So we hope to share this with you the moment the bulletin is out for the year. We have FILJA alerts about administrative cases affecting judges and court personnel. They are immediately given the latest decisions to remind them about the conduct and I think the manner of behavior in court. Okay? And the journal, as we said, from time to time are thematic. The latest issue that we have is the law of the sea. It has become big because of the South China Sea dispute. So we have a justice who fortunately studied so well the UNCLOS and has now become the champion. In fact, he went to the Permanent Court of Arbitration with a delegation of government lawyers, no? To argue that case in the PCA. He was one of the resource persons. No? So again, champions in the Supreme Court would be very important in trying to put into the map certain concerns nationally. Okay? And we have special publications. This is a policy approach. The multi-year development plan of government also asks the court from time to time how the criminal justice system will also be an important component of the entire development plan of this country. So there's a chapter in the development plan about the justice sector. Okay? Special publications are specific projects of the different departments in the academy to develop handbooks on, for example, commercial law, or this one also is on marriage. No? These are small pockets that can be distributed like monographs to some of the judges who have interest in these issues. Okay? And e-learning programs, of course, is now being introduced, no? Since it is the most facilitative and easiest to access right now for many of our court personnel. Okay? So I think...
How does it work?
Sorry?
How does it work? E-learning?
E-learning, these are very directed modules online. So we will tell the judge, do you want to open a module on psychological incapacity for purposes of understanding the developments on nullity of marriage? So you would have a collection of expert opinions on that. And they will project it, no? You can access it and say, this is the latest on the matter. And we develop, for example, the use of electronic evidence in court. Arrest, for example, very common. What are commonplace issues that judges would actually want to learn more about it? No? So we have from the members of the academy, some of the different departments with expertise. No? They are contributing to the development of small modules, but this time online. You can just inform the academy and say, I want this module, please send me. So during their spare time, they don't have to go to a training like this. They can be in their private homes and then during their spare time, study the module on their own.
You record your modules in the academy?
Sorry?
You record the modules in the academy? You have a studio here?
No, that's not the studio. You know, when we went to the National Judicial Center, Elmer and I were there, no? Attorney Elmer and I were there to see a studio. I envy that, no? Because they can bring in a justice or a judge, no? To be placed in a studio, and they develop a scene, and then they talk, and they are filmed. So I said, how much did this entire, it was about this big, how much did this entire room cost you? And then Miss McQuinn, of course, no, brought us to the National Center for State Courts, where in the College of William and Mary, they have the most advanced courtroom. You've been there, Justice. Very impressive. I said, how much will it cost? So I began to discuss this with our colleagues and say, can we not go to the TV stations and help us develop it, right? I mean, we are not short of access, no? Of course, we will be very sensitive with the influences because sometimes they have cases in court, right? But I think it's the technology that can be used. But I found that very interesting. You sit there, you're an expert, they film you. And then that could be used to distribute to the other judges and court personnel. So things are changing, and it's good to have this interactive type of, I think, exchange, no? And visits, no? And I hope that we should be able to do something along that line in the future. Okay. So I guess I have exhausted my time. I hope that was helpful based on our experience, but I tell you, our experiences are not just from our own experience, but it was drawn also from the benefit of other judicial training institutes. And we are prepared always also to share with you our products and our services. Thank you very much, and thank you for your participation.
Thank you very much, Dean.
Thank you.
So we saw actually the hard work of Dean Candelaria in the Philippine Judicial Academy. We'll provide you 10 minutes
Thank you.
as health break. We have some snacks the right side of this hall. So we'll be having the second presentation after our health break. So see you in a while.
Thank you. Thank you, sir.
Snacks we provide here in Manila, in the Philippines. It's quite plenty. So you can imagine our appetite here in the Philippines. In lieu of Dr. Richard Fee's presentation, who sincerely sent his regrets for not joining this year's conference, an equally interesting paper entitled Gender Audit on Gender Responsiveness on the Judiciary Project, with two co-presenters will be shared to us. Please welcome newly appointed Assistant Court Administrator and Acting Chief Attorney of the Supreme Court of the Philippines, Attorney Maria Regina Adoracion Filomena M. Ignacio. You can call her simply as Attorney Gina. With co-presenter, Attorney Cleofe Jetty Sandoval, consultant of the Gender Responsiveness Audit of the Judiciary under the Philippine Supreme Court Committee on Gender Responsiveness.
Thank you, Attorney Elmer, and good afternoon, everyone. So I will be talking about the historical background of the Committee on Gender Responsiveness in the Judiciary and the first ever gender audit project that has something to do with decisions of the court. So the creation of the Committee on Gender Responsiveness in the Judiciary was brought about by Supreme Court Administrative Circular Number 22, 2003, dated March 27, 2003. Historically, it was first chaired by Associate Justice Maria Alicia Austria Martinez and co-chaired by no less than the then Associate Justice Adolfo Z. Ascuna, now the PhilJA Chancellor. The committee membership consists of justices from the Supreme Court, Court of Appeals, Sandigan Bayan, Court of Tax Appeals, as well as representatives from the Philippine Judges Association, the PhilJA, and officials from core offices of the Supreme Court. The current composition was brought about by the reorganization when the court issued Memorandum Order Number 42, 2015, and is now led by no less than Associate Justice Teresita Leonardo de Castro as chairperson and the Court of Appeals Associate Justice Remedios Salazar Fernando as its vice chairperson. On the slide are the members of the committee. Sandigan Bayan Presiding Justice Amparo Cabotaje Tang, CA Associate Justice Leoncia R. Dimagiba, Sandigan Bayan Associate Justice Maria Teresa V. Mendoza Arcega, CTA or Court of Tax Appeals Associate Justice Cielito N. Mindaro Grulla, Deputy Court Administrator Jenaline Aldecoa de Lorino, yours truly as the Acting Chief Attorney, Executive Judge Georgina D. Hidalgo, the President of the Philippine Judges Association, Professor Mirna S. Feliciano from the PhilJA, Attorney Eden Candelaria from the Office of the Administrative Services, Attorney Corazon Ferrer Flores of the Fiscal Management and Budget Office, Attorney Theodore Te from the PIO, and our Head of the Program Management Office, Attorney Renely B. Mayuga, and Attorney Maria Victoria Glores TSP Guerra from the PIO. What was the legal basis for the court to create this committee? The following were the legal basis. Section 14, Article 2 of the 1987 Constitution on the promotion of the role of women in nation building and ensuring fundamental equality before the law of men and women. RA 7192, otherwise known as the Women in Development and Nation Building Act, mandating the removal of any gender bias in all pertinent government regulations, circulars, issuances, and procedures, and ensuring equal benefit and direct participation of women in development programs, projects, and processes, and the various general appropriation acts directing the formulation of the so-called Gender and Development Plan, the cost of which shall be at least 5% of the court's total budget. The creation of the committee was also in response for the urgent call for the gender mainstreaming in the judiciary through the integration of gender and development principles in its policies, programs, and structures of the court, particularly by undertaking, coordinating, and monitoring judicial activities that promote gender responsiveness. To achieve these ends, the CGRJ is tasked to formulate a comprehensive guide plan and program of action for the judiciary with the objective of promoting gender responsiveness in all courts and court personnel. What is its mandate? First, remove gender bias and ensure that women benefit equally and participate directly in the development of programs, projects, and processes. Integrate gender and development principles in the judiciary's policies, programs, and structures, and prepare a guide plan to mainstream the gender in the judiciary's policies, programs, and activities. What are its core strategies? First, to transform the paradigm and enhance the commitment of the judicial system to gender equality through training and capability building. So, examples of this are judges, court personnel undergo the so-called gender sensitivity training programs. Even the court personnel from the highest, from the Supreme Court down to the lowest level of the trial court, undertake gender sensitivity training programs so that when they deal with the public, they will be more gender sensitive. Second, review or conduct gender audit of policies, programs, and practices to make these more gender responsive. Establish a gender responsive database on the judicial system. To promote the use of gender fair language, core gender messages, and rituals for higher gender awareness. Enhance partnership and networking with other God advocates. Organize regular family courts throughout the country and create a committee on decorum and investigation in each court station and train CODI members. As mentioned by Dean Candelaria a while ago, when the courts, family courts were not yet organized, regular RTC courts were designated as family courts. But the family courts, which is subsumed in the CJRJ, for the past 3 years, was very active in the creation of the regular courts. It means they will be created specifically for that function. And at present, there are already 3 tranches of created family courts. The first tranche composed of 50 additional courts. The second tranche is composed of 48 courts, and the third tranche is composed of 37 courts. The subcommittee, since there are 8 core strategies, the first is composed of the training and capability building under the leadership of Professor Mirna S. Feliciano. This is where the gender sensitivity training comes in. Also, we conduct stakeholders meeting to solicit awareness and feedback on how the family courts or the internal rules of the court as regards the committee on the CICL or the children in conflict with the law, the family courts have, so that they will be, if there are gaps, there will be remedies to address. And at present, I think we've already recommended to the court certain amendments of the internal rules. And since there will be created family courts, the infrastructure part was planned ahead before the creation because it takes time to get budget from Congress. And the live link facility is an important aspect because there, the confidentiality of the proceedings of the children are really protected, and their traumatic needs are addressed by the presence of the social welfare officers, and they get to testify in the presence or with the assistance of people who they are comfortable with. So the second subcommittee is the Gender Responsiveness Database in the judicial system, which is headed by Attorney Teodorte. So right now, every meeting, Attorney Te, who is from the PIO, updates the committee as to the number of cases that deals with family courts, the children in conflict law. And then the third subcommittee is the Gender Responsive Welfare Services, headed by Attorney Eden Candelaria. And the accomplishment is the establishment of our child care center within the court. The fourth committee is the Partnership and Networking with Other God Advocates, headed by our PMO head, Attorney Mayuga. And then the Organization of Regular Family Courts is headed by DCA Jenny Lind Aldecoa de Lorino. And the establishment of CODI and training of members is headed by Associate Justice Leonardo de Castro. And the resource mobilization is headed by our Fiscal Management Office head, Attorney Flores. And the Subcommittee on Gender Audit and Policies is chaired by no less than yours truly as the acting Chief Attorney, with the following members: Professor Mirna Feliciano, Attorney Guerra, Attorney Del Rosario from the Office of Justice de Castro, and Attorney Donna de la Cruz from the Office of the Chief Attorney. Now, what is the Gender Audit Project? The Gender Audit Project, because of its mandate to perform adjudicative functions vested upon it by the Constitution, the committee will conduct an audit of the Supreme Court decisions from the years 2007 to 2016. Why 2007? Because in 2006, People versus Cabalquito was promulgated by the court, and this initiated the protection of the confidentiality of the child victims by using pseudonyms, like if the name of the victim is Gina, it will, in the information and in all the transcripts as well as in the decisions, the name Gina will be substituted by, say, AAA, and all the personal circumstances by which the child would be identifiable would also be substituted by, say, BBB or the father named CCC. So its aim is to measure gender sensitivity and responsiveness of the Supreme Court through its decisions promulgated from the years 2007 to 2016. Why? Because the Supreme Court, as well as the trial courts, their main function is adjudicative. So it's the direct impact has something to do with the decisions they make. Later, Attorney Jetty Sandoval will discuss in detail how the audit will be conducted, the methodology, the sampling size, etc. Now, what's the project goal? The project goal is to develop an audit tool which is universal, applicable from Supreme Court down to the lowest level of the court. But initially, it will just cover the Supreme Court decisions. And later on, it will be cascaded from the appellate to the trial and as well as the Sharia courts. The Sharia courts are the Muslim courts existing in the Philippines. And then it will also strengthen gender responsiveness initiatives in the judiciary. Why? Because it will provide a feedback mechanism to the committee on whether the interventions such as the training, capability, enhancement of the personnel, the judges, are effective and what needs to be addressed. And also determine future steps to achieve God plan objectives. Why is it client-focused? Because the main subject matter of the audit would be the decisions. And we believe this is the first gender audit of decisions in the world. According to Attorney Jetty, there's no gender audit of decisions undertaken by any country yet. So we are very interested in the outcome of this gender audit because it will be really giving the court a complete picture on whether the circulars issued to address, let's say, strict adherence to the confidentiality in the decisions of the court judges are adhered to. And People versus Cabalquinto, promulgated in September 19, 2006, is the main decision which led to the purposive sampling of 2007 to 2016. And then one accomplishment also of the CGRJ is the issuance of the use of gender fair language in the courts, which was done in 2006. And when the Asia Foundation and the Department of Foreign Affairs and Trade of Australia heard of the gender audit project of the court, they became interested and they partnered with the court by hiring consultants, the terms of reference of which were also made in consultation with the court. And right now, the three consultants, mainly Attorney Jetty, who is a gender expert, a statistician, and a programmer, are on board. And right now, the status of the case, the status of the project is we are in the process of developing the tool, which will be translated into a programmable tool, and then the statistician will help in the methodology. So without further ado, I would like to call on Attorney Jetty Sandoval to give us all a detailed overview of the gender audit of the Supreme Court decisions. Thank you.
Thank you very much, Attorney Gina, and good afternoon to everyone. What I'm going to share with you this afternoon are the detailed processes and methodology in terms of implementing this gender audit tool. The objective of my sharing is to give the current initiative of the CGRJ in developing the assessment on developing an assessment tool on gender responsiveness of the judiciary through the decisions initially of the Supreme Court. But as Attorney Gina said, eventually the plan is to cascade this to include also decisions of the trial courts. How was the project conceptualized? As mentioned earlier, this is mainly through the creation of a committee, which basically is an implementation of laws passed on to ensure that there is gender equality, including in the judiciary. These also include the issuances of administrative memorandum on matter on gender fair language, as well as the decision, as mentioned earlier, of People versus Cabal Quinto, and the support, of course, of the Asia Foundation and DFAT Australia. The objectives of the study would cover measuring gender sensitivity and gender responsiveness. Now, in the experience of the Philippines, there is a law in the country that mandates that all government agencies, including the judiciary, should set aside at least 5% of its total budget for gender and development-related activities, programs, and plans. This initially was included in the annual appropriations issued by Congress, approved by the Congress of the Philippines. But in 2009, this became part of a law called the Magna Carta of Women, which is really the implementation of the Convention on the Elimination of All Forms of Discrimination Against Women. So now it is a legislated provision that mandates the whole bureaucracy to allot at least 5% for gender and development projects. This, for the purpose of measuring the bureaucracy's implementation of this law, there have been tools, gender audit tools, assessment tools, monitoring tools developed to measure implementation of projects, implementation of programs. But there has never been a tool developed to assess contempt of decisions of courts. So in that sense, therefore, this project is pioneering, and what we want to happen is to see whether the court is aware of gender-responsive principles, whether the court is aware and recognize gender biases, whether it is aware of gender discrimination as a principle, and whether it is able now to translate these principles on gender responsiveness, basically as defined by CEDAW and as defined later on by CEDAW General Rule 33, issued in 2015, which basically laid down women's access to justice and how the courts and the judiciary should make sure that women and gender discrimination is prevented against in the judiciary, or that the judiciary will not be a tool to further gender discrimination, and that it will help arrest gender biases, stereotypes, in accordance not only with international treaties, but in accordance with domestic law, with national laws. So what this project wants to find out is to what extent is the court, through its decision, able to translate all of these principles that they gained through the training provided by PhilJA and other international organizations, and all the learnings that have been passed on to the court, how these learnings have been translated into actual decisions. Because one of the tool where we can see how the court thinks and how the court's mindset is at a particular time is through the decisions that it issues or that it promulgates. So this is the core of this project. There will be three outputs mainly. We will produce a tool, an instrument that will measure, including a system. So as Attorney Gina said, this will be web-based. There will be a manual, of course, that will accompany it, and there will be a training for the assessors. what guides us to make sure that this project is aligned with international principles as well as with local laws. Of course, understanding what the principle of gender equality is, not just de jure or not just in law, which is what the Philippine Constitution provide, but actually equality in results, which is what CIDO is after. Meaning, it is not only equality before the law, but equality in practice, whether or not the law is translated in the day-to-day lives of men and women, as well as non-discrimination principles. We also want to ensure that we understand that how we construct the role of men and women affects how they are treated in society, and if there is inequality and there is bias, then discrimination can occur, as well as in understanding what stereotyping and gender bias mean against women and children. We also want to understand or to ensure that the discrimination prevents men and women from full fulfillment of their enjoyment of their rights, which is really the purpose of gender equality, to make sure that there is full participation in the different spheres of lives of men and women, which include the judiciary as part of the state in ensuring that there is elimination of all of these gender biases and gender discrimination. We, of course, are guided by the Constitution, our domestic laws, the rules issued by the Supreme Court, as well as our international laws and covenants that the Philippines is a state party to. Now, how are we designing the tool? First of all, the intention is to have a tool, as mentioned earlier, which can be used by the court of all levels. We are designing a tool that will allow indicators to look at the facts of the case, the decision, which are basically divided into three parts: the facts of the case, the reasoning, and the remedies provided by the ponente or by the court. The indicators correspond to elements of CIDO GR 33, as initially mentioned, which provides elements on women's access to justice. The indicators basically cover four areas: the use of gender-fair language, the awareness of principles, the awareness and knowledge on laws and procedure, as well as the remedies. We initially are starting with looking at decisions of the Supreme Court. So the project started in June of this year. We hope that by December of this year, we have evaluated the sample size from the decisions of the Supreme Court from 2007 to 2016. There will be assessors who have been trained on gender, and they will be the ones who will actually use the tool. There will be developed a rating system where the level of gender responsiveness can be assessed, and whenever necessary, there may be instances of case studies on selected cases or relevant cases. The methodology also include automation. Now, quickly, I will not go through any detailed explanation here, but just to say that this will be web-based. This will be electronic data gathering online platform where the assessors will be able now to respond to the indicators using the web. How will we get the sample size? Based on our assessment on the number of cases decided by the Supreme Court, and based on our identification of cases using keywords related to gender, we ended up with a probable size of around 345 cases, meaning these are the number of cases that the assessors will read and will be subjected to the assessment tool. There will be it will be stratified, meaning we will determine the sample size by year as well as by the nature of cases. So for example, we will determine the share of, for example, 2007. How many cases is the share of 2007 compared to the 10-year period? And that percentage of case will be the number of cases per year. And or how many nature of cases, how many criminal cases, how many administrative cases, etc., are decided in 2007, and then that will be a share of that will be the sample size. No? So, as mentioned by Attorney Gina, a statistician is part of the team to be able to determine that the optimal sample size that we will get is reliable in terms of its sample size, as well, of course, as making sure that the tool we will going to develop is valid in terms of ensuring that the elements of gender responsiveness is present. The range of the rating will be from less responsive to most responsive. So there's a range where grades will be provided based on the responses as gathered by the assessor. So indexing just means that the grading will come from several indicators. Right now, what we have developed is a set of 12 indicators that cover questions relating to the knowledge of the court on principles, on procedures, on how the court is active in terms of pointing out stereotypes or biases in how courts are, or in the, of course, as gleaned from the decisions that come before it, that are brought before it. The gender responsiveness, the scores, therefore, will be based on the responsiveness per case as well as responsiveness per indicator. So for example, this is just an example. The findings, for example, because your question is, so after all the testing that is done, so what? So what? What is the relevance of the results? The results will, for example, say the gender responsiveness in the judiciary has improved over time, and therefore that is why the stratification is per year. How has the court improved from 2007 after Cabalquinto came out and after all the administrative matter, for example, on gender fair language has come out? How has the court applied that? And how has the court through time, 2007 up to 2016, improved in terms of making sure that the court contributes to gender equality in its decision, in its views of biases and issuances against gender-based issues, particularly that come before it. So, for example, this would be cases that refer to sexual gender-based violence cases, rape, sexual harassment, trafficking, or family-related cases where violence is involved between the spouses, or where child abuse is involved. How has the court applied the laws that were mentioned earlier by Dean Candelaria? How has the court been aware that it needs to contribute to make sure that the court becomes more child-sensitive, gender-sensitive? So that's the intent of this project. Of course, afterwards, we will submit the results to the committee for the committee to determine how it will be fed into its projects, how it will be fed into its programs. That's why we added in the presentation the mandate of the committee, because all of this will be fed into the programming of the committee from here on. I think I will stop there just to say that we are in the process of developing this tool. We have identified the indicators. We are finishing the scoring. We have identified the sample size, more or less. What we plan to do is to do the actual assessment early December. We think a week 3 or 4 days is enough for the assessors to read the case and to adapt the cases into the tool, to answer the tools. There is a sort of in the process of checking the cases, not more than one assessor will read one case, so that there is a kind of a check and balance to be able to see whether the appreciation of the assessor is more or less valid. So we're thinking of having 3 assessors reading a similar set of cases. So, and we hope that by the end of December, we will be able to have the results of the survey, no, or of the assessment. So I will stop there. We are willing to accept or hear your comments or questions and even suggestions as you listen to the plan. This is not far from being a perfect plan. This is, as have been mentioned, an attempt, a first attempt, we think. Of course, you can correct us if we are wrong, but I think this is the first attempt anywhere in the world. I think there's a small experiment done somewhere in Boston or in one state in the US on this matter, but of this regard and of this extent, I think this is the very first time using Supreme Court cases to begin with. No? We hope also to include, of course, the Sharia court. So part of the indicators include questionnaires on decisions of the Sharia court, because the Sharia court is part of the trial of the lower court system. So thank you very much for listening, and we are ready to accept any comments or any questions from you. Thank you very much.
The design of the study is very attractive, and of course I believe that it will be useful for not only for the full-time course, but the study will be benefited to other jurisdictions as well. I want clarity on a few issues. When you talk about collection of data, you said some certain questions have been articulated. So will you going to put to the judges, advocates, to whom you will be inquiring, or you will perhaps, I think you are referring that some cases will be scrutinized, some cases will be scrutinized. The cases means the pleadings or the judgments, orders. Which part of the pleadings will be examined, or the judgment will be examined? If you start examining judgment, then you would be able to identify bottlenecks and weaknesses of judge. And if you start pleadings, then would be examining and assessing the ability of and understanding level of the advocates or lawyers. So what would be your, who will be your respondent rather?
Thank you very much for the question. We will be assessing the final decision of the courts, in this case, the Supreme Court. So the 345 or so cases are final promulgated decisions of the Supreme Court from 2007 to 2016. What will happen is, this is your decided case, this is your questionnaire. The assessor will read the case, then will read the questionnaire, and will see whether there is a fit. So for example, the questionnaire will ask, did the court identify gender biases in the narration of facts? For example, yes or no, something like that, and so on and so forth. And then there will be assigned scores for the answers of the courts. Of course, what we want to see here is the level of sensitivity and the level of awareness of the court, or the lack of it. Because, of course, there are decisions where maybe the courts will show. So we will not go into the pleading, sir.
Right. Most of the cases are decided and would be pending before the trial courts.
Yes.
So and there are hardly few cases which goes up to the Supreme Court. And the judge of Supreme Court might be so sensitized and he would be taking care of gender bias issues. But the issue is with the district level or the subordinate judiciary. So perhaps you need to identify respondents from the lower side of the judicial system. And secondly, when you talk about the analysis, so may I know what sort of analysis tool will be used, how you will be analyzing? Most of the time in our legal system, the documents are perused as a person examining that document may frame certain opinion. So sometimes his opinion may go on this side or that side. So perhaps when we are starting this type of research, so perhaps we need to use some statistical software such as SPSS like that. That would be perhaps more helpful, and you will be blaming on the SPSS rather a person, and you will be saved from the content of court notice.
Thank you very much. Well, to begin with, what we want to produce is what we call a universal tool, meaning this will not only be used on the decisions of the Supreme Court, but on decisions of trial courts as well, or lower courts. But what we will look into only are final decisions, the promulgated decisions only. We will not go into other submissions to the courts. Therefore, the lawyers, the litigants, the litigators will not be, in a sense, directly evaluated. It is the language of the court. This is a content analysis. We will analyze the writing and, of course, the mindset of the judge that wrote the decision. You are correct. The challenge that came to us as we are doing this, one of the challenges is how do you minimize subjectivity? Because you are going to use people who have their own mindsets, and the level of training on gender is also not the same. There will be uneven levels of training on gender, or even the appreciation. Even assuming they went into the same kind of training, the appreciation, the awareness, the capacity to accept, etc., will be different because these are human beings. And therefore, hopefully, to the extent possible, the tool, the questionnaires that we will develop has reduced subjectivity, because for every question and for every answer, the assessor will include the source. So the assessor, because this is web-based, the assessor will cut and paste the source from so for example, if the assessor will say, the judge is biased, there is bias in the decision of the judge, for example, the assessor will now cut and paste the concrete paragraph or sentence or line where he or she feels the judge has been biased. So, and as I said, so that's the first protection, as it were. The second would be more than one person will read one case. So we will average the responses of at least 3 people. Hopefully, we would get a more or less reliable response or conclusion. Based on, because these 3 people will do the work separately. They will not be talking to each other anyway. We will also assign ratings per question. So we will average per question and as well as the total. So therefore, you will see per indicator, which represents awareness on principles, awareness on laws, beliefs, their own capacity to suggest changes or suggest in the remedies and in the reasoning. You see how the mindset of the judge works and whether or not the judge has any opinion towards any bias or discrimination or abuse that is presented before the court. So each question represents a particular set of knowledge that we want to find out. So they will be rated. So we will get an average upon which we will base the assessment, the conclusion on whether or not the court at that particular year for that particular nature of case has been or has not been gender responsive. So what we want to hopefully find out, of course, is a progression. What we want to see is how the courts have been progressing, hopefully, rather than regressing, in terms of its appreciation, its knowledge on laws. As Dean Candelaria said, courts should be able to know laws that have been passed, especially to be able to make the courts more gender sensitive, more child sensitive, environment sensitive, etc., etc. So this is really an assessment of how far the program of the Committee on Gender has really gone down to the mindset and revealed through the decisions or the writings of the court. That is what we want to find out here.
Right.
My question is on the impact of the laws themselves on the decisions of the court and on your findings. Have your tools factored in situations where the law or the rules being applied themselves were gender biased? That is one. Secondly, or seem to be gender biased. Secondly, I'm not aware of so forgive me if it's not your department, but you mentioned it. What is the scope and the jurisdiction of the Sharia courts? And now them applying different, as presumably if it were the same with my jurisdiction, different sets of laws that are completely of different nature, how these your tools have been shaped or maybe reshaped to suit the circumstances of those courts.
The basis of this project, we have enumerated laws that have been passed recently to make sure that we address biases or insensitivities. So what this study wants to find out is to what extent those laws have been internalized by the courts and how these laws have been applied. And in instances where the laws remain to be antiquated, remain to be biased, remain to be partial, to what extent can the judge recognize these biases or these laws? And will the judge proffer any opinion on the matter? Of course, we understand that as writers of decisions, you only write or you only respond to issues brought before the court. And therefore, it may be difficult to find decisions where there will be a treatise of, how to respond to discrimination in society, etc., etc. Of course, understandably, we are not looking for that. But we have seen decisions where the court, in simple comments, are able to bring forth its opinion on certain laws, and therefore that is what we want to catch, hopefully. On the matter of the Sharia court has jurisdiction over family relations, over marital relations, family courts, family-related issues. There is a law that covers it, and Code of Muslim Personal Laws that cover the jurisdiction of the Sharia courts. We hope that the discussion as well on equality between men and women among our Muslim brothers and sisters have also affected or have also influenced our judges in the Sharia court. So we wanted to find out, for example, if they are able to include fatwas, hadiths, Quranic verses, even that respond to gender equality whenever it is, of course, relevant to the case.
This guy is the same rule you apply.
We'll take Judge Tan's question as the final question.
The question is, how do you assess gender fair language? Because a few years ago, we were asked to attend a gender seminar. And we were advised not to use any more men, women, language in our judgment. So I'm refraining from using this term. I use now persons. So the policeman testified that he saw two persons, one male and one female. So that's how we use now in our judgment. We don't use men, women, and
Judge, the specific issuance of the court as regards use of gender fair language, there are four basic principles therein. Like, if before, the traditional sentence reads as the architect reviews his blueprint. Now, the more correct way, or being gender insensitive, is the architect reviews the blueprint. So maybe in the decision making, we suggest that judges look into the examples enumerated in that administrative matter, because when you read through it, you will realize sometimes it's just like a minor difference in his or her, but it really makes an impact. Like chairman, before we used to address it as chairman, but now the proper title or designation is chairperson, because it can it can be directed to a male or a female or an LGBT or whatever type of identity or sex or person orientation a person has.
In addition, Judge, in the indicator, we adopted the administrative matter on gender fair language. So part of the questionnaire is to ask whether the decision is gender fair using the administrative matter guidelines. So whether or not the decision followed these guidelines. So if the decision followed these guidelines, then yes, then you are gender fair. Because other than that, there is at this point no way of objectively checking other than the issuances made by the Supreme Court. So part of the intent, therefore, is to see how many judges or justices, for that matter, follow its own issuances.
Thank you very much. In today's IOJT session, Dean said Candelaria explained how thematic research can be really translated into actual trainings, capacity building, or development initiatives, curriculum design, as well as publication. More so, he explained to us that it can transcend into court rules revision or even policy change vis-a-vis engagement of all concerned stakeholders. So in the second presentation, it's actually appreciating gender awareness and responsiveness through working research. Research project as explained by attorneys Gina and Jetty. So at this point, we are really thankful to our presenters for taking some of your time, precious time. So let's give them a big hand. So we can notice really who are those interested in research in this hall. Thank you very much for coming.